We will now commence our third panel discussion for the day. The current economic crisis has or will lead to a record number of businesses being rendered insolvent. Our next panel will discuss whether Sri Lanka has the robust resolution framework necessary in order to resuscitate these businesses. To start off, I would like to invite Dilshani Wijayawardana, lawyer and board member of Union Bank PLC and former commissioner of the Securities and Exchange Commission of Sri Lanka, on stage to deliver a presentation.
Okay, good morning, ladies and gentlemen. Thank you for inviting me to address this August gathering at a critical juncture of our economic history. Sri Lanka's economy is in a critical state of health. The fact remains that many corporate bodies and even individuals will be bankrupt at the end of this crisis. Many corporates, as we speak, remain in the proverbial ICU state, fighting to survive. Some amongst them will certainly die, while some others, with some external help, can be resuscitated. An efficient, reliable, and transparent insolvency regime is sine qua non for a robust financial system and plays a key role in the reallocation of productive resources, investor confidence, and forward-looking corporate restructure. Under our legal system, when a company is insolvent, it can be wound up under the Companies Act of 2007. In the case of an individual or a partnership, they would be declared insolvent under the Insolvencies Ordinance of 1884. I leave it to you to do the maths as to how updated our insolvency ordinance is. The law on bankruptcy is essentially procedural in nature. Its role is to organize a collective regime, ensuring the preservation of pre-bankruptcy entitlement to the maximum extent possible. Till the enactment of the Companies Act of 2007, when a company faced insolvency, the only available option was to wind up that company. However, under the present Act, alternative legal mechanisms are available to resuscitate a company. These provisions will be discussed by me shortly. Before I proceed, I like to flag that there are certain duties, fundamental duties, when a company is facing insolvency. And I'm sure many companies, as we speak now, is in this state but unaware of this legal obligation. Under Section 219 of the Companies Act, there is a duty cast in law to each and every single director whose company is facing insolvency and unable to pay its debts to forthwith call a meeting of the Board of Directors to consider, one, whether you should file a petition to wind up the company or to appoint an administrator to run the business of the company. Failure to do so will expose the Board of Directors and each and every single director to personal liability. I repeat, personal liability. So most directors are completely unaware of these legal obligations or duty. And I think and this time of crisis, it is extremely important that you be cognizant of your legal duties. Where a company is not viable, the main thrust of law should be for a swift and efficient liquidation. Due to the time constraint, I will not dwell on this topic, for it is mostly procedural. But hopefully we can discuss it in the panel discussion. As Sri Lanka steps into its darkest decade with the current economic crisis, many businesses will struggle to survive. The question remains, are there provisions in law to resuscitate them, or should we let them to die? It is a truism that rescuing a business preserves employment, potentially provides creditors with a better return, and obtains for the country's economy the benefit of a restructured, rehabilitated regime. The Companies Act of 2007 has two broad schemes available to resuscitate a company. One is to a compromise with creditors under Part 9 of the Act, and voluntary administration under Part 13 of the Act. Truth be told, that unlike other jurisdictions like the UK, Australia, New Zealand, which has the identical provisions according to published data shows that these are the most resorted to provisions in these jurisdictions. Here in Sri Lanka, either due to the ignorance of its existence or simply incompetence of our professionals to work them, these legal restructuring tools are much buried in our statute books. As they say, never let a crisis go to waste. This may be an opportune time to have recourse to the restructuring tools to resuscitate distressed companies. Part 9 of the Act deals with compromise with creditors. This part sets out the procedure by which a company can enter into a binding compromise with its creditors. What does a compromise mean? It's a compromise between the company and its creditors, which includes cancelling all or some or part of the debt or waiving the rights of its creditors or the terms of the debt. In the UK, a compromise with creditors, absolutely similar provisions that we have in Sri Lanka, is governed by the UK Insolvency Act of 1986. What is interesting to note is that in such an agreement in the UK is supervised by very trained, expert people called insolvency professionals. Now, who is an insolvency professional? They are what we call insolvency practitioners trained as professionals who have gained a very broad, wide practical experience, and they are licensed to practice as insolvency practitioners, and they are licensed and regulated by a professional body. Sri Lanka has no such profession, and in this time of crisis, God only knows we need them. So maybe this is an opportune time to introduce such an expert set of professionals. The other mode to resuscitate a company is voluntary administration under Part 13 of the Act. Voluntary administration is an insolvency procedure for companies having the potential to be rehabilitated. They are in the ICU, not dead, struggling to survive. So for such companies, there is a ventilator option, which is called voluntary administration. This is a new concept under the Companies Act, and it's modelled under the New Zealand Companies Act, which in turn is modelled under the Australia's Corporation Act. And according to data, in Australia and in New Zealand, when a company is in distress, this is the go-to sections. But again, unfortunately in Sri Lanka, they still remain buried in our textbooks. Administration is a voluntary process initiated. Who initiates a voluntary administration? It's the company. Why? Because it is the company who knows how good, bad, and indifferent your financial situation is. It is a board of directors who actually know how good, bad, and how critical your state of health is. So it is a process by which is initiated by the board of directors of a company. What happens in an administration? When the company is in administration, an independent administrator is appointed. The administrator takes control of the company's business and acts as the company's agent. It also can enter into binding contracts on behalf of the company. Now in Sri Lanka, we do not have professionals to become these independent administrators, and if these are worked, most likely some accountancy firm will be called upon to be an administrator. Whether they have the skill set, I leave it to the audience to decide. However, in the UK, administrator will assess the business potential, whether there is hope for this company to be turned around. As I said, in the UK, which has identical provisions like in Sri Lanka, for an administrator has to be a qualified insolvency professionals. And I think the business community here should seriously consider looking at the criteria, how business insolvency practitioners are trained, they are regulated, they are licensed, they are absolutely with very broad spectrum of experience to take a company, turn it around. And we do need such professionals. What does administration mean for a creditor of the company? When an administrator is appointed, there's an automatic moratorium on anything due to creditors. It is not possible for creditors to bring or to pursue any legal proceedings against the company or its assets. There's a moratorium. Also, upon the appointment of an administrator, directors' powers are curtailed. A director cannot exercise any management powers which is in conflict with the administrator's duties. If the company's turnaround comes out of the ICU and is healthy, then the board of directors will take over control of the company. With the onset of the COVID-19 pandemic, the UK introduced a new piece of legislation. Unlike Sri Lanka, they seized upon an opportunity to bring about change, and they brought about this piece of legislation called Corporate Insolvency and Governance Act of 2020. Under this act, upon a director's making a statement saying we are insolvent or likely to be insolvent, the court will appoint a monitor. Basically, the board of directors will manage the company, but the monitor will supervise to see whether proper steps have been taken to resuscitate the company, to turn it around. And as I said earlier, a monitor is again an insolvency professional. Perhaps Sri Lanka should take a leaf from such legislations which are specifically designed to resuscitate companies during an economic crisis. Before I conclude, I would like to suggest few ideas which have been successfully implemented in other jurisdictions, just food for thought. In Sri Lanka, the law relating to insolvency is found in the legal patchwork of material. You want to see Insolvency Ordinance, which is of 1884, which deals with insolvency of individuals and partnerships. Companies, it is under the Companies Act. Then there is state-owned corporations, they are under that particular statute. So it's a myriad of legislations that deal with insolvency regime. Countries like the UK and even India, surprisingly, brought all these pieces of legislation under one umbrella. I think recently Murtaza emailed to me I think the committee papers, I think the policy papers in India dealing with the new insolvency and bankruptcy code, which is of 2015. And I'm like, oh, wow, oh, great. I'm sure it will take a couple of years for it to be enacted. And I researched on the internet, and I was like very pleasantly surprised. Policy papers of 2015 was implemented in law as their new insolvency and bankruptcy code in 2016, just less than 12 months. Where second thing that I think I would like to suggest and discuss further is to bring about this new set of professional called insolvency professionals. All advanced jurisdictions have them. They manage, they are very trained. They are basically have particular exams to follow. They are constantly updated with the new knowledge, new business environment, and they are regulated. There is a professional body that you have to be part of. Hence, I think it's an opportune time we look at a professional body set up during this economic crisis. Another suggestion, which I think India has brought about, is setting up a tribunal to look into all these insolvency and bankruptcy matters. Because with a composite tribunal with a specific expertise and qualification to determine matters relating to insolvency and to do away with going to court, our last resort, unfortunately, has sadly proven to be inept and absolutely inefficient. Also, it is no secret that laws delays is a serious bugbear in our judicial system. India, under their code, which is absolutely salutary, has addressed this issue by stipulating a timeline. You have given 180 days to resuscitate the company, or you can go to court and ask for extension, but there is time frame. So you can't sit there and let one person with a dilatory tactics prolong this entire process. In Sri Lanka, I think even in the last session, delay. We can't get anything done expeditiously, and when it comes to delay, delay is time and delay is money. So I think there's a suggestion I strongly recommend, because when we go to court system, we are bogged there for decades, and a time-based resolution on insolvency proceeding. Another reason there is delay in insolvency proceeding is lack of information. India set up this amazing new concept called information utilities, which is pretty interesting. It's like a portal where you have to upload all your information, your accounts, your creditor list, your payment schedule. It's a pretty sort of a it's a structured setup where you, as a creditor of a company, could access that portal and get information about your debtor. So in the case, you technically know how good, bad, or indifferent the health situation of the country, of the debtor is. So another thought to ponder about setting such a system where information, critical, can be accessed by creditors. I think Sri Lanka's financial sector should lobby for change, for a more efficient, transparent, and expeditious insolvency regime in Sri Lanka. When is the time to act? It is now. Sri Lanka is currently raining with opportunities for change. And when it is raining opportunities, we should put out a bucket and not a thimble. Thank you.
Thank you, Dilshani. Those are certainly very salient points to consider. Please do take a seat while we invite the rest of our panelists onto the stage. I would first like to invite Dr. Harsha Cabral, the President's Counsel. Mr. Nirosh de Silva, the Managing Partner at Horizon Partners Limited. Along with the moderator for the discussion, Chanaka Wickramasuriya, Consultant. Over to you, Mr. Wickramasuriya.
Afternoon, everyone. Let me start off by trying to put some context to all of this. Now, yesterday, I think we all heard Dr. Veerathai saying that how Thailand had introduced a very sort of robust bankruptcy mechanism in their path to getting out of the crisis. So I think he was quite emphatic about it. So needless to say that it's something that we are going to need as well. What is also worthwhile remembering is Thailand had a considerable amount of fiscal space that they had going into that crisis or coming out of it, even in terms of Thai baht debt being considerably low. So they had the fiscal space to support their banking systems, create debt recovery vehicles, capitalize debt recovery vehicles, etc. Needless to say, we have absolutely no fiscal space. It's an understatement to say that we have any. And let's face it, banking sector NPLs are going to go through the roof. Hopefully not to the crazy levels that they experienced in Thailand, where I think he's mentioned that he went up to something like 47%. But with the current high interest rate regime and the demand contraction working its way through P&Ls over the next year, over the next 6 months, through this whole fiscal year, NPLs are going to go through the roof for the banking sector. A few statistics also to perhaps put this in context is that, and these are just gleaned out of, speaking to some of the bigger banks. If there's anybody from bank supervision out here, I'm stand to be corrected. But typical recovery rates on secured debt in the banking sector is about 70% on capital, 70% of capital, and maybe about 25% of interest. So if you work that out, it's still less than 50%. That's in a reasonable macro environment. So needless to say, going forward, that's going to go down further. Also worth noting that 60 to 70% of the SMA book is clean. And when I say clean, it doesn't have any fixed tangible collateral behind it, and perhaps about 90% of the corporate book. So for the banking sector, this is very much going to be the need of the hour, that we are going to need a very robust debt recovery mechanism, company restructuring mechanism that sits outside the court system. Because as we heard from Dilshani also, otherwise the court system is going to get inundated. A standard liquidation process, even with parate, sometimes with injunctions and even mortgage laws, I think, Dilshani, you can correct me, it would take anything sort of 5 years. And that's only going to get pushed further down the road if courts, like I said, courts get inundated. So all this points to the simple fact that liquidation is obviously not going to be the answer. We need some other mechanism. So with all that in context, can I start with you, Harsha? You heard Dilshani saying, where we are, and maybe you can just give us a little bit of, my understanding from Dilshani was that we do have some sort of insolvency process embedded in the legal provisions. Maybe a little bit about history, how they came about, when they came about, and if it's inadequate, what do we need to do to get there?
Thank you. As a corporate law practitioner and a person involved in reforming the law, I will try to share some thoughts. Firstly, we have traditionally been following the English law. So we have had the statutes based on we initially had the 1860 Joint Stock Companies Act, where again we had liquidation in that. Then in 1938, we had the Companies Ordinance. Again, we had winding up procedure in that. Then in 17 of 1982 Companies Act, we had that. So when it came to law reform and for the new Companies Act come to being in 2007, there was a gestation period of about 9 years. So in the process, we had to look at, we were given 10 basic pillars, sort of position papers. And one happened to be to look at this aspect of winding up. So the traditional concepts were not working. And I would try to emphasize on the weaknesses we have in our system. The biggest mistake I see is, the winding up position in the Companies Act, Dilshani referred to, is supported by the winding up rules. Now, the winding up rules are 1938 rules. So you can imagine how archaic they are. To start the winding up, then to proceeding it winding up, how the creditors come in, how the provisional liquidator is appointed, liquidator, receiver, the reports they have to make, all this is based on the 1938 rules. Absolutely archaic. Even under the new Companies Act, the rules we have followed the old rules. That was meant to be changed. That is one. Then in 7 of 2007, a new provision was brought in, Dilshani referred to, the administrator. Part 13 deals with that. Exactly from sections 400 to 426, brand new 26 sections were brought into the Companies Act for administration. On top of that, as Dilshani mentioned, we have the compromises and arrangements, creditors, things and all that. So when this was discussed, it was finally decided by the Company Law Advisory Commission at that time that insolvency and business turnaround is something that we have to look at separately. Because the Insolvency Act, the totally archaic 1800s Act, was basically for individual insolvencies. If you look at the old case law, you would see that a lot of individuals, they declared themselves insolvent to get away from several other liabilities. That was a very common thing, but that doesn't happen anymore. So, leaving that part out, we came up with the 7 of 2007, dealing with the administrator part, then the existing compromise, and the traditional winding up. Now, winding up under the sections from 266 to 399 deals the entire part of winding up in our company law. That is basically the old law we had. There are no improvements done because we were thinking of looking at a separate law to deal with that. So traditional winding up system we have in our system is basically winding up by the court. That is, there are situations where there are several grounds given how to wind up a company. And then the second mechanism is members or creditors voluntary winding up. And the third is winding up under the supervision of court. So the most common thing is the winding up by court, the first one, because voluntary winding up and voluntary creditors winding up or members winding up is rather difficult, because if there are liabilities, it's very difficult for them to approach that route. Now, other mechanism of winding up is a fairly easy thing. Say, for example, if the company is unable to pay its debt, you can move court to wind up the company. Now, the amount that is referred to, actually we increased it from 5,000 to 50,000. It's now 50,000. So inability to pay debt, so any creditor can send a letter. It's not a letter of demand. It has to be by under the hand, and saying, well, if you don't pay this amount, I'm going to wind up the company. Now, when we go to court, it is pretty easy to get this company wound up, because you make that application. Then initially when you support that application, the court gives you 2 days. That is one for the publication. It's a newspaper publication. And the return of that to court, the returnable date. And the appointment of a provisional liquidator, who becomes a liquidator thereafter. So, the legal fraternity, as I must say, misused to a certain extent. There are friendly winding up. You get a friendly creditor, so send that letter, and the company comes and says, well, I have no objection. You wind up the company. So, and you know that when you go to wind up a company, that procedure with our system, the loss delays, can be taken from, say, 5 to 20 years, right? Because if it's a final appeal to the Supreme Court, the appeal will come up only after about 10 years. So they know very well that this limited liability concept of where the shareholders are liable to up to the extent they have will never happen. Because by the time this thing is over, well, you don't find anyone. There was one particular case I was involved, one of the supermarkets. There was this, someone moved to wind up the company. Definitely a situation where the directors want to get away. They had sold, siphoned off monies, all that, and then a winding up petition. Then the company comes and says, okay, we are in a position where we cannot go forward. We are not objecting to the winding up. Now, to object to the winding up creditors, there were some 800 odd creditors. Because all these people who have put a miris packet or whatever little things to the supermarket, they were creditors. So there were 800 odd creditors who walked into that courthouse and the courthouse was packed. And the poor lady judge, she got frightened. She couldn't accommodate this crowd because everybody is trying to file proxy. And she asked me, how do we get out of this? I said, no, you give them a date and say before that you file proxy in the registry and make because under the rules you can do that. So that happened. Ultimately, no one got a cent because our system is such, when there is a schedule, once you are raking the claims, very often in a winding up, you would see that the assets are not enough to meet the liabilities. So liquidator will finally come and say, well, these are the assets, these are the liabilities. So there is a schedule where you rank the claims. Now that is in, I believe, Schedule 9 of the Companies Act. What happens is, well, the statutory payments are made, then the secured creditors take the other one. So the unsecured creditors rank last. Invariably you get played out. You never get your claim, so it is not worth going to courts for a winding up. Because by the time you appoint a liquidator, because most of the audit companies, they have their liquidators, they are appointed, and that never works. And there are reported cases from 1886 to 2021. If you go through all those cases, you would realize how winding up or liquidation has failed in this country. It's a total failure. Now, the other problem is, rather than going to wind up the company and become a creditor, there are other mechanisms for the lending institutions, especially the banks. They have that power of parade execution. So it's rather easier for them to use that rather than going and falling in this queue. So this is better for them, okay, go for parade execution, recover whatever, and get away. Now, unfortunately, this has not worked. So then look at the other two amendments, the two areas Dilshani mentioned. Compromise of creditors, well, our creditors can never agree. Right? In Sri Lanka, it's very difficult for two people to agree. So, I mean, if a bigger creditor is the bank, they will know how to get that. So, creditors' meetings are not workable in Sri Lanka. Then comes the administrator. We brought new sections for administrator. And that again, for the now, we have had this Companies Act for almost 15 years. I don't think for more than 3 or 4 instances, the administrator provisions have been used. In one case, I believe Mr. Neelakandan was made, the late Mr. Neelakandan was made the administrator. And he was telling me how difficult it was to go and, to restart the factory. He had to go to the provincial council. He said, 100 times I have gone there, I couldn't get it going. So that's the worst part of it. Now, unfortunately, when we were doing that particular reform, there was something we had to look at. We thought, well, now internationally, people don't let companies die straight away. That is the last thing. So, business turnaround, business recovery, there are so many things you can think. Now, for example, the US Chapter 11, which works very well. Chapter 11, then we looked at several other jurisdictions. There was a Dhanaharta model that was introduced in Malaysia after the banks started collapsing. Then India, Sikh Industries companies, Dilshani mentioned, and also the English insolvency regime. They work very well. So what we did was, there was this organization called Business Recovery on Insolvency Practitioners of Sri Lanka, and we drafted a law. I was personally involved in drafting that. We looked at the Malaysian model, we looked at the Indian Sikh Industries companies, then the British, the UK Insolvency Act and the developments, and also the US Chapter 11. And we drafted that. Now that mechanism was to turn around the company, not to let that company fall straight away, not to go into winding up, not to go into administration, but to try to resurrect that company. How to appoint a committee, the company law committee, how to place it on record in court, and then keep the directors away, because you can't get the same directors to run the company which collapsed. Now, if you look at after Enron, there were good laws that were brought in. Even in India, after Satyam, right, say Satyam, they resurrected that company in a short period. But we just couldn't. We had, if you start from Pramukha to HPT to all the old finance companies, let alone the newer ones, the Golden Keys and the others, there were situations where we needed business recovery. Now, the business recovery ensured that maybe insolvency practitioners or insolvency experts have to come in. As Dilshani said, there is Insolvency International organization. You can get accreditation. We have a couple of members, we are all accredited members, where they tell you how to do it. Maybe you have to downsize the business, you have to reduce the number of employees, you have to cut down on expenditure, so many things to do. There are experts to look at it. And for them to do it, and that the formula we brought in had a system where time frame is given. You've got to do this in 21 days, you've got to do this in 21 days, like that, short periods. So when this was presented, unfortunately, we had a seminar and we invited the Chief Justice at that time. So he said, no, don't bring it as a separate law. Why don't you bring it as an amendment to the Companies Act? Now that draft is still there. After thorough analysis of all the foreign jurisdictions and the failures they saw in India, all that is there, draft is there. Now that has been sitting there for over 10 years. Unfortunately, in this country, so now basically at our age, we try to give up. There is no point in, because there are no votes in this. So it was very difficult for anyone to go and push this, right? As against the lending institutions. Well, they still have their parent execution. They don't have to go and enter into a moratorium where they say for 2 years we won't touch that, because that was moratorium was one in that particular draft. So that draft, we sent it to the Law Commission. Law Commission also looked at it. But when with this regime changes, you know, the think tanks also change, unfortunately. So whatever that has been started by an earlier regime won't be carried down. New heads will come. And whether it's good, bad, or ugly, since it was created by an earlier regime, then no one will carry it forward. So that is where we stand. So we see a whole lot of companies reeling, and as Dilshani very correctly says, not only the insolvency regime, there are a whole lot of other provisions which are available in the Companies Act to avoid this type of crashes. She mentioned about 219, that is the insolvency situation, how the directors are responsible, civil and criminal liability. Then serious loss of capital under 2020. Then we have a section called solvency, 57. Every company has to maintain solvency. In my book, I have referred to it as a golden thread that runs across the entire fabric of company law. Because you can't have issue bonus, you can't declare dividends, you can't buy back shares, you can't have tamashas. The company is not solvent, but the directors are solvent. Now, I can tell you personally, the people, I do quite a number of winding up cases, and the directors of these companies who come to see us to wind up the company, they still come in their S-Class and the 7 Series BMW. But they can't pay the employees 15,000 EPF. You see? So there are garment factories, I mean, very small salaries. The girls have not been paid EPF, ETF, and they have to go to the winding up court, and ultimately they don't get anything. So it basically has not worked in this country, because maybe even under the existing statute, the provisions have not been worked. And well, the judges also must have commercial thinking, and parties know that taking advantage of the loss delays, it is easy to go to court and block it there. And everyone knows that when you go to wind up court of a company, well, that's the end of the matter. You can forget about the liabilities. So that is my view on this. Well, a lot of opportunity, especially for the younger generation lawyers. I saw several young lawyers here. I always tell them, well, look here, you all look at it in a different way and try to reform this.
Thanks, Harsha. I'd like to shift gears a little bit. Nirosh, you've been sort of at the forefront of trying to resurrect companies, and you'll come head to head with these types of creditors. And how have the legal provisions or the interpretation of current legal provisions or the practice of them been a hindrance, or have they helped? And what have your experiences been?
Chanaka, I would like to spend a minute just to put. Yeah. I'd like to spend a minute because we keep focusing on the Thai experience and this 47% NPL rate, because I think from that we are going to cascade into how many tough situations we are going to have in the coming year. The Thai crisis was a creation by the private sector. The Sri Lankan crisis, as we've discussed, is a creation of the government sector. So our private companies, even though they're in difficulty, are not as badly off as the companies that the companies were in Thailand, because those big construction firms and the big hotel groups and the big office buildings that came up, that the cranes stopped for 5-6 years, that kind of level of dollar debt is not there in the Sri Lankan balance sheets. Having said that, the policy rate increase that the central bank governor had to do is understandable. But if we keep those rates at those levels, we are going to struggle, and that's going to bring down a lot of the struggling companies. So I understand what the central bank has to do, but the money printing happened also from the government. The policy objective of taking interest rates up is going to mess up about 30% of our companies. So the NPL infection is going to come from that side. I think we need to put that out there. Coming to the point of the insolvency laws. Before I get to insolvency laws, I'd like to give an anecdotal thing that happened to me. In 2009, a friend of mine, quite excited that Sri Lankan war had ended, wanted me to incorporate a company for him. He lived in the US. I incorporated this business for him. He was going to come and do a software business in Sri Lanka. Then the husband and wife decided, no, they are not going to come back to Sri Lanka. And then they told me, can you give this company to somebody? And what? I said, no, I just made the decision, no, I'll close it up. So I told the company secretary, please wind this company up. So I thought that was matter ended. Then I get a very nasty letter from the Inland Revenue saying that I have not filed my taxes and to immediately come to the Inland Revenue. So I sent my audit firm. Now this company did not even have an audit. It didn't even have a bank account. To cut a long story short, in 2015, the Inland Revenue was threatening to freeze bank accounts, was of a non-existent company. It was threatening me as the sole director to come to the Inland Revenue, and this was kind of unprecedented nonsense, right? And now business has not even started and you can't close a company, right? My first interaction, actually this one of the clients who had many S-classes and many sports cars, had a dispute with, actually the factory workers had a dispute in 2009, and actually they nearly smashed up my vehicle also. Luckily, they didn't react in that way with me, but they smashed up the entire office, and I made the recommendation to the board, with unruly labor, you cannot continue this business, so let us wind it up. And we had enough grounds, and I took on the responsibility of, helping the lawyers frame the case in court. That case went on for 6 years. The bank basically felt these people are rich, so we can try to bring personal liability on them and shake them down to that there is the go beyond the aspect of limited liability. Two banks couldn't agree on how to execute the parate execution, so there were other complications. There was a dispute as to whether a particular asset was a movable asset or an immovable asset. And the list of issues went on. And at the end, a poor judge who had no commercial experience and no understanding of how to read a proper balance sheet had to make judgment on this. So those are two experiences. One where I hadn't even incorporated a company. And right through, I feel that if I had to avoid one of my clients going to court, I would take that option. I have another client who has a BOI business. And the business is in difficulty. And the BOI would send, the BOI has, I think, about 800 people in a unit called enforcement. Right? Every politician who comes and makes grand pronouncements about the BOI, that they are going to bring the $1 billion and the $2 billion, they look at the staff and say, no, I'm going to bring my team. Then what do they do with the existing team? Put them into that division. Right? So those people have to keep busy. Right? So they are checking on whether the company is paying their EPF, ETF. They are checking whether the company is filing taxes. Now, all these jobs are already being done by the EPF department, by the Inland Revenue, right? But these people are also busy digging holes and covering them up, right? So now this company is bankrupt, and we want to proceed in court, but can we convince now that this company has a license to operate, right? We can't convince the BOI to come into a compromise, to give us time, right? They say, no, whatever you want to do, this has to be paid. Our fees have to be paid. Otherwise, we are going to basically terminate your license, terminate your company, your approval process, and then you lose everything. Right? You lose your approval. So there are instances where we've looked at the compromise solution that Dr. Harsha Cabral talked about. But again, the aspects of commerce and the aspects of debt are so complex, and the creditor arrangements are, quite complex, that we feel that when you go into court, you're going to have, if you have to end up for 2-3 years trying to resolve the matter, you're going to kill the company anyway. I want to take a step back and say, now, in this economic climate, why is it important that we try to use the law to protect these distressed assets? It's because they might be in difficulty, but those are some of the most productive companies in the history of Sri Lanka that have gotten into a bad space. If you let them go, and if you frustrate those directors, and if you frustrate that capital, you're going to lose productivity of about 20 to 30% of our private sector over the next 24 months. So that's why it's important, if we are actually serious about the health of our private sector, that we need to try to harness this. I want to spend 2 minutes. I asked permission from Chanaka, and I also in the morning spoke to Murtaza. This crisis is going to have certain impacts on our financial system in varying degrees. And it's very important that our regulator uses regulatory sanction properly and quickly in an appropriate manner to resolve matters. As a child, I remember going to buy a ticket at the Savoy Cinema. And my father drove into a side road and he said, Puta, I can park here. Then I said, you might be blocking somebody. And he said, no, don't worry. This is the Mercantile Receiver's Office. I'm the one who picked the building. I can park here. My father used to work in the central bank. Right? And so I went and bought my ticket, and that was it. Then we went off. But on the way out, I remember, as I would have been maybe first year university, him telling me, Puta, this is an exam. I thought when we took it over that we could have managed this, but it's become an absolute nightmare. In 2009, there was a well-run finance company with adequate capital that the central bank took over. And I think about 6 months ago, they put it to bed. They put it to rest permanently. Right? They tinkered around with the finance company for 10 years. Nothing was broken. They broke it. And that cannot happen in this impending next 12 months. We are going to have much more challenging times. And I feel there's a lot of capital that can be raised from overseas markets, both for our private sector entities, and if we can use the legal system, the reformed legal system, to support these struggling companies. There are some good brands that are going to get knocked out of the market. Those brands can be brought back with foreign capital. Those financial institutions also can be taken to the next level, and a financial sector consolidation can be done using foreign capital. We're all talking about how to get foreign capital, right? These reforms in the legal system and reforms at the regulatory level can be that conduit for foreign capital. And I think that's very important for us to understand how much is riding on these reforms. Because if we fail to take this opportunity, we are also failing to basically bring in much needed foreign capital to Sri Lanka. Thank you very much.
Listening to both Harsha and Nirosh, it becomes increasingly more evident that we need a process and a mechanism outside the court system. Dilshani, I'd like to move to you. Now, you said that within the existing companies law and act and recent amendment, I think, there are two provisions, compromising with creditors and voluntary administrations, appointing a voluntary administration. So my question to you is, why do you think those two mechanisms haven't worked? Harsha mentioned how, trying to get a whole bunch of creditors to agree is impossible given, sort of the diverse interest. He also pointed out a scenario where Mr. Nilakandan, I think, was appointed a voluntary administrator, and, he faced challenges. So are there tweaks to those two ordinances that we need in order to get greater buy-in and usage for them to be effective?
Okay. With regard to compromise with creditors, as Harsha said, it's true. You can't get two people to agree. And one of the ways this was tackled in the UK during the COVID-19 crisis was, as I mentioned, they brought this new piece of legislation in 2020, Corporate Insolvency Governance Act of 2020. Under that particular piece of legislation, they obviously knew you put 5 creditors in one room, they are not going to agree saying, this is how we are going to take a haircut. Why is he getting a haircut like this? Why is it more for me, less for him, so on and so forth. So under this particular legislation, court can even force a creditor if it is for the greater benefit of resuscitating that company. And as I said earlier, under this particular act in the UK, which was particularly brought to combat so many companies and businesses that was going under during the COVID-19 crisis was to ensure that the macro aspect of is more important. That is to make sure that the company survives for the greater benefit of the employees, the state, so on and so forth, and not the pity-potty bickering of a particular creditor. So I think in terms of why it hasn't worked in Sri Lanka is because there is no sort of compromise when the creditors are called in to say, okay, we are going to compromise on how this particular agreement has to be. 75% of them must agree. So as leave alone two people, 75% of the value of the creditors must agree at a meeting of creditors. Okay, this is how we are going to agree, and this is the binding contract. So why probably it hasn't worked is that that culture of compromise, give and take, bigger picture doesn't work. As with regard to administrators, why it hasn't worked is I personally think, this is my personal take, we don't have trained people. Absolutely lack. There's a lacuna in people understanding how to structure a company. If you want to appoint an administrator, whom will they appoint? Some accountancy firm or some retired lawyer or a judge. They have no clue how to take this business. They are not business savvy. First of all, you have to understand the business. Then you must know how to work the balance sheet. So we do not have this particularly trained set of professionals. Either we are absolutely bankrupt with our set of professionals, or there is no will to sort of create this professional body in every other jurisdiction. They have insolvency professionals. They are trained with a forensic mind to get into a company, study it, analyze it in a period of a short period of time. You're not given, like in Sri Lanka, as Harsha said, it goes for years and years. Time is of essence. There, you are given 180 days or 6 months or whatever, and told, okay, you got to turn around this company, and you need brilliant minds to do it. I'm not at any point of time saying that Sri Lanka does not have that kind of mindset. We do. But we need to get them and to train them and to probably even create a particular professional set of body. And I think why these provisions, which are greatly resorted to, in Australia, they say that the most sorted out statistically provision is administration. They have, like in the UK, insolvency professional, and when a company is in distress, they file a paper saying they are unable to pay their debt. When you say unable to pay their debt, I have to make it very clear. Unable to pay their debt is not the same as not having enough assets. Sometimes you can be asset rich, but you are unable to pay the debt as and when they are due. So I think answering your question, Chanaka, is basically lack of having trained set of professionals to deal with this kind of situation. India has brought them, UK has them, New Zealand has that, United States have that, Australia has that. Maybe this is an opportune time we should look at. Yeah. Thank you.
I'm going to come back to all three of you actually with regard to how we can fast track this process. But just to finish off a couple of things on the existing companies law, Dilshani, is my understanding correct that right now it is a company and its directors and its creditors that can call for, who can call for a restructuring of a business, not a liquidation. I'm not talking of liquidation. Who can call for a restructuring of a business? Okay. And does that provision need to be tweaked to make it more practicable in this current environment?
When it comes to administration, it is a board of directors. The act is very clear. I think section 401 says board of directors shall call for appointment of an administrator, because they, at the end of the day, are the very people who knows the true picture. It's a self-governing situation, so they know how good, bad, and indifferent the companies. So when it comes to administration, it's the board of directors. When it's the compromise of creditors, I think there is a list of people who can call in for. One is the board of directors, a receiver. Receiver is a person who's appointed under the Companies Act, where a creditor, for example, to execute a property, you appoint a receiver. Administrator can ask for a compromise. If I'm not mistaken, even a shareholder and a creditor, with the sanction of court, can say this company needs to have a compromise so that the survival of that company is so ensured. So answering your question, if I voluntary administration, it is board of directors. For a compromise, so many people, which includes board of directors, receivers, liquidators, administrators, creditors, and shareholders.
Yeah, but again, through the process of the courts.
Compromise with creditors, yes, it is through the process of court.
Yes, but in other jurisdictions, in your experience, do they have to go through
India is amazing. I just love the fact that they set up this tribunal, which is so extra judicial with great expertise.
So great. So just in the interest of time, let me jump to that for all three of you. We need to get to a mechanism and even tweaking this mechanism pretty fast. We don't have the luxury of time. Let's just start with you, Harsha. So there are three things in my view. One is we may need to tweak the existing laws, to circumvent the courts. The second is get the necessary human infrastructure in place, insolvency professionals, bodies licensed, properly trained, etc. And the third is the one thing that you mentioned with regard to India also is the availability of information. Right? So I'm going to put it on to all three of you. How do we fast track our process to get there quickly? We don't have the ideal scenario here, right? So India, you said, implemented it still in record time, but still it took 12 months. We probably don't have 12 months. Harsha, to start with you, please.
Yeah, I would suggest that amending laws or going for new laws is not the answer. Because if you see, the Companies Act is now 15 years old, we are still struggling to amend the cosmetic changes. There are a couple of changes which we have listed out, which we listed out about 8 years back. Still that it has not become law. So forget about new laws. Country is now worried about the 19th Amendment, 20th Amendment, 21st, going back to 13, what to do, right? So we have to work within the parameters of the existing law, right? Existing law has the provision for administrator. Like the country is looking at my good friend, Mr. Harsha Silva, to become administrator and fix things up. Companies do need such people, well, competent people, to come forward. Okay, downsize is, do this, sell this, okay. We have excess amount of staff. We were talking about BOI. I'm a former BOI chairman. My friend is there. I was on that board a couple of years ago. 1,800 people working there. We can run this place with 300 people. But if you do that, you lose elections.
So Harsha, just to drill into that, who is an administrator? Who is classified as an administrator?
The board can, they have not given any qualification as such. That's why I said Mr. Nilakandan was appointed once, then Mr. from BDO, not BDO, the other place, Gerard was appointed in another case. They were quite competent. It's not a, they are trained, they are either chartered accountant or any other profession, right? Where you can have consultants for themselves. They wouldn't know everything, but they can hire expertise, right? Okay, this, we have to downsize, give golden handshake to X amount of employees, sell this asset, do whatever. There are a couple of things they might have to do fast. But if that drags on for 5 years, then you're finished. Banks won't wait. They don't want to join the party creditors club or moratorium or anything.
So, Dilshani, do we need to tweak the provisions to ensure that this process, now Indian process has a timeline?
Yes.
Right? They're very emphatic about the fact that time is of essence here, because you can't let this process drag on, because the company's institutional and commercial capital in itself will deteriorate. So do we need to tweak this to ensure that there is a timeline provision?
I personally think so, because India was experiencing the same thing that we have in Sri Lanka. I think probably it's a South Asian mindset, time is not that of a great essence. And we are very litigious kind of a mindset, and I think Indians are no different. So they realize that to get the best out of, to resurrect a company, to turn it around, if you tell them, okay, guidelines are set, it won't work. So the law in its black and white legislative format said 180 days. If you want any extension, you have to go to court, not the court, the tribunal, justify why you want an extension. If not 180 days, and that's it and no further.
Nirosh, in insolvency professionals, you've gone through the process, so you know the skill sets that are required. How can you fast track licensing people? What do they need to, what kind of experience do they need? What kind of qualifications do you think they need?
I feel somebody who has accounting or even an economics background, who has at least 5 to 10 years of being on a board of a company, who has some management experience of at least mid-level management. I think that's the kind of caliber of person you're looking for. Two aspects I think we've touched a lot on India. So the Sri Lankan creditor who is extending credit, I think lots of you are business people, so you would be doing this. You are extending credit without a dashboard or without any knowledge of the financials of the company you are extending credit to. And that's a very different scenario in India. I was actually evaluating buying into an Indian business for a client of mine. And I was surprised at the amount of level of detail he has. You can get into the Credit Information Bureau of India and you have access to their to the credit report. So if there are check returns or if there are issues on the financials, you can have access to that as a creditor. So you are forewarned about the situation. Right? So that kind of information, if you can make the infrastructure is there in Sri Lanka. If you start making that available, then the creditors start knowing a little bit about the problems this company is having. What happens in Sri Lanka is all of a sudden the company can't pay. Right? And by that time, it's generally too late. So if you can open up the credit scoring system to all people who, I mean, if you want to take credit from a third party, you have to open yourself to the credit scoring system and allow. So if I want credit from Murtaza has to have access to my credit. That's one. The second thing I feel that's important and that's working in India is that the whole aspect of trying to resolve matters. I think India is, while people are litigious, they are more pragmatic in their approach. Okay, let's try to sort this out like this. We don't have that in Sri Lanka. One of the third point I would like to see is whether within, I know the banks are going to get very upset with me for saying this, but if a compromise or a administrator is coming, right, being considered by the board, by the court system or recommended to court, then the parate execution should be stayed for at least 6 months until such time the plan is brought. Now what happens is the person with the parate execution has almost like can it, and it doesn't have to wait.
Just correcting that, Nirosh, for administrator, moment an administrator is appointed, everything freezes. You cannot go for parate. Compromise with creditors, you don't have the moratorium.
So
but for administrator, everything ceases. That's kind of a breathing space. The company can truly look at and say, okay, this is how we are going to restructure. And even
again, in that, the point is the bank cannot agree.
Yeah, there is an issue because the
bank cannot agree.
The banks are very powerful, so they can even go and get an injunction. Drop
or
off a hat, you can get an injunction.
To the plan.
No, but I must add something to the credit of certain banks. I think Mr. Ranjit Fernand will agree with me. Banks have helped a couple of companies to restructure. They have the expertise. They have, forget about the law and the courts. That is the biggest problem we have in this country, right? So Leave the lawyers out. My heaven's sake, I'm also a lawyer, but they are the worst fellows to trust. But you keep them out in a very commercial way, get some competent people who have experience in restructuring, maybe double accountants or whoever who have experience in reforming companies. Get those people and do something.
My sense is I'm hopeful that the banks will see this.
There's a lot of value getting destroyed. That's my concern. These companies all have a history. They have brands. They have knowledge, and we are losing all that in these closures.
And the fact that we have a legislator in the audience, so we need to give him something to take away from this. Otherwise, he's wasting his time.
Yeah, I would suggest that, especially the time frame. For example, you just can't postpone. Say, look at Sri Lankan. Every month you postpone, you're adding tremendous pressure on your coffers. Then the others, like now you've all started something, I think the CEB, petroleum, let the players come or do whatever. But those are things you have to decide then and there. You have been talking about this Sri Lankan issue for how long? During your regime, then the last regime, every time a new board comes. So they happily go on and they will not.
Yeah. So again, just to wrap up, we need a few tweaks to the existing laws and provisions to ensure things like timelines and things like that. We need a licensing regime for administrators, insolvency professionals. Am I right?
Insolvency professionals, just to add, in most jurisdictions, it's a professional body itself. You cannot be an insolvency professional unless you complete the examinations.
Right.
Then you are affiliated with ACCA, CIMA, all sorts of bodies like that.
Right.
So, and you to renew your license, you have to keep constantly, you have to pass an exam every year. So they are, not only do they, you should know your finance, technology, everything.
Yeah, but Dilshani, we don't have time now.
We don't have
we
time,
don't have time,
yes.
so we need to try and find a mechanism to, filter people based on their experiences and qualifications, existing experiences and qualifications, and license them into these roles quickly, right? Do we need to do anything in law to improve the flow of information? Wouldn't the existing information available through the auditors, etc., would that suffice, Nirosh, for an insolvency process?
No, every company has their own accounts, right? So they all know about the accounts, right? Any audited accounts enough to start with. And basically, with that information, you can do that. That's why I always say, keep the courts and the lawyers out of this, retired judges or present judges or whatever, because then we think in a different way. How to block this, how to get an injunction, how to drag this, right? That's a common perception.
So the bottom line is that the existing laws and provisions are adequate. We need a bit of a mindset change amongst the banks, particularly, and the creditors, to be able to function into a
one thing I would like to add to what Nirosh said. Basically, when the creditors get to know how bad the debtor is, it's basically closing the stable doors after the horse has bolted. It's too late. India has addressed that in their new code by setting up information utilities. So you have a center forum where you file on all the information. So the creditor is in par with what is going on in the debtor. So if he wants to step in and say, you know what, let's go for a compromise, your balance sheet is deteriorating, or see the debtor in distress, you have that possibility. Right now, the current scenario that we are currently in, the creditor gets to know when you're completely gone belly up. So that is something we can look at too.
Okay.
I think the important point is the creditor. The creditor oftentimes thinks of restructuring too late. That's happened. So in my practice, I've restructured about 25 companies over an average span of about 2 years for the last 20 years. That's been my practice. I would have got about maybe another 50 to 75 more clients who seriously I looked at to consider for restructuring. But most of the time I notice that they've come to me too late and there is no value to be created. It's just like they're trying to come to me and try to keep the bank, prolong the thing for a little longer. So I don't take clients like that. And I believe that's the other takeaway I can give. I mean, if you're in business, what's very important is getting the credit information across to the counterparties. That's, I think, one thing Dr. Harsha can do, if you can get that enacted immediately. Number two, I mean, in consultation with the banks, see whether we could get a bit of extra time for administrators and compromise situations both. And I think if those two things can be achieved today, the qualifications of the administrator, those things can be long-term work in progress, because I don't believe that you can have shortcuts to that. That's improving the skill level, right? That there's another one point. I feel that when you start taking on these roles, there is absolutely no immunity in law when you take on these responsibilities. And being an administrator can be a very challenging role because you're dealing with a bunch of people and you're putting on a proposal. And I believe that's something that also needs to be looked at, because that profession can't undertake unlimited liability on account of a professional engagement.
Do we have...
Contrary to that, I can say if you want to kill a company, go to the lawyers.
I don't think that will be in the interest of the financial sector, to be honest. So I don't know whether we have time for questions. There's a clock ticking here that says 2 minutes, but I'll open it up. Dylan? Oh, sorry.
Mr. Fernando Pulle and Mr. Mr. Fernando Pulle will take his first. He knows how to kill company because he comes from Mr. Ramesh Silva's chamber. So you have enough experience we have, no, Buddha? Yeah, go ahead.
Just the thing, I mean, interestingly, we are at the moment restructuring our country. So when what if Chance and Hogan, Lasads are doing is actual restructuring, because there is no court process, because you can't bind up a country, but New York law is at the moment looking at a Chapter 7. So there is a Chapter 7 process that's been going, consultations going on. So what is happening is the Chapter 9 is being mirrored in consensual process. So what happens, my understanding of Chapter 9, I'm not expert at Chapter 11, is that there's a DSA involved, there's a debt sustainability analysis. And using the debt sustainability analysis, you come up with instruments and valuations which allows you to turn around the company. And that's where the basis of this is. So I think in Sri Lanka, we would probably, the challenge is to understand judges who can look at this debt sustainability analysis. And what happened, my understanding is in London, the High Courts opened a special division and who are trained to understand debt sustainability analysis. Next thing is the development of a bond debt market, because you might have to sell off the debt or transfer the debt, and people are willing to take a risk. Conversion of debt into equity, creating options, those are things where judges have to understand and to turn around a company and give time and space. That's what my understanding of what has happened. One issue that in India, I think it's because India has a series of tribunals, from the company law tribunal, the debt tribunal. So India gets around its federal structure by creating these tribunals. In Australia, England, all of the Commonwealth, it seems to be it's kept the courts because they use the equity provisions and the trust provisions as powers of the judges to restructure companies. And that's, I think, important, that unfortunately, because there is question whether our judges have equitable jurisdiction in that sense. But that's what they've used. For example, they use tracing, they use constructive trust and resulting trust provisions. So I think using the equitable jurisdiction, they can use change debt into equity, give them instruments. One thing about the creditor compromises, I think what you definition of creditors in the voting, the biggest thing in what you call schemes of arrangement is the creditor classes. So you look at, instead of looking, if you look at classification, like if you look at secure definite immovables, movables, you get them into a creditor class that they can, voting structure allows you to vote on it, like what's happening in Sri Lanka also. There's in what you call the collective action clauses. It's all about creditor classes. So that they have creditor committees that are going appointed, and that's why I think what you need to think. Look, judges need to be told is that you don't need to let all the creditors. When you make 75% of creditors, you may push all the secured creditors and unsecured together and change and use equity provisions and get them to vote.
Yes.
Thank you for a very interesting discussion. Being a banker for all my life, I just can't stop myself from making some comments. I think the core issue in a restructuring is not a legal issue. It is a financial restructuring issue. It is a job for a financial professional. So that is the first mistake we are making by trying to look at handing over to courts and the lawyers, with all due respect to the lawyers. I'm myself a lawyer, but I think it is not the remedy. I think it must be given to a financial professional. And I like to relate an experience of mine. During the past few years after retiring from the bank, I was invited to become the what they call the competent authority under the Underutilized Assets Act, which was passed some time back. Under this act, several companies and other state-owned enterprises which had become defunct and were not functioning, and there are a lot of assets lying with those companies idle. So this act was passed in Parliament, which took over all those assets and vested the land and the assets in the state. And there was a competent authority appointed to look at the restoration of these industries, restructure of the industries, or the sale of these assets, so that the country would benefit from idle assets lying over. So under this, there were many companies, like big state companies, like I think some of the bigger ones are spinning and weaving mills and things like that in the Minuangod area. But there was a specific competent authority appointed for one of those. But there were 26 industries of the BOI which were in this category, which were taken over under that. And a competent authority was to be appointed, and I was invited to take that role. And in one of my weak moments, I agreed. And I really handled that task. And I must say, out of the 26 industries that were handed over, 21 was restored within a period of 3 years. Now, the procedure was, now this land was already vested, the assets were vested in the state. So I had to start by calling the earlier entrepreneur who had stalled the operations and asking, are you prepared to restart the thing, or have you finished? So some of them said, I had different problems. Now I'm ready to restart. So in that case, I had to ask them, okay, what is your plan to restart? I had to look at the balance sheets and the borrowings from the bank and the viability of the restarting process. That is a judgment that you have to make. Otherwise, you're pursuing a dead horse. Sometimes euthanasia is a better option. So I had to decide whether there was a chance of this person restarting the thing. Either there was lack of equity, in which case he had to bring equity, and if there was a debt, I had to speak to the banks and see whether it can be rescheduled. But all that depended on whether the first judgment that there was a chance that this could be operated on a viable basis. So if that was the case, we worked with that person, spoke to the banks, rescheduled the loans, and brought in equity if necessary, and allowed him and got recommended to the BOI that he be given a license again. The license was cancelled. So BOI went through the appraisal again and got an approval from the board, and he restarted. Now, there were cases where the person said, I'm not prepared to restart. I have finished then in that case, we had the opportunity to sell the assets. So we had to advertise in the press, call for quotations, and call for any other person who wanted to take over the industry and run. And again, we had to look at the viability or sell the asset. So it was a process, streamlined process, where the asset was first vested in the state. So I think some model like that, where you take the business and really vest the assets and really so that no one can interfere with you working, and call the party and call any party, whether it is with the same party, and assess the viability of the proposition that he is making, what conditions brought him down, and whether those are rectified now. I think Nirosh has done a lot of successful ones, where the same process, it's the question of trying to see whether there is a viable thing or whether you're flogging a dead horse. So it is a professional for the financial person rather than a legal issue.
Thanks,
Sure.
Tilan.
Only
And
60
then Lan.
seconds. I'll take only 60 seconds. Number one, Harsha, though you're my friend, I disagree. I think we need Chapter 11 legislation. Companies like Sri Lankan Airlines would have had more choices. And I must say that legislation taking time is an excuse, because yesterday I was attending the first meeting of the CB restructuring committee that I've been appointed to by the new minister. And we were told that he needs to come to Parliament with a new bill within 2 months. Number two, our financial markets. I agree on one point. Our financial markets are underdeveloped, and we need to develop our financial markets to address some of the restructuring issues. I've been talking for 5 years for LLP legislation to be brought into this country so that private equity can come in to restructure some of these companies, but we failed to introduce LLP legislation despite my putting a team together, doing it pro bono, handing over to the former Finance Minister Mangala Samarivira, got it into a budget statement, not implemented. Number two, 1.5 years ago, when I saw this crisis coming, my team and I, we did pro bono work and gave it to the then Deputy Governor Nandalal, draft proposal connected to creating a bad bank, because we saw the distress assets coming in the hotel sector, which has been under stress for 3 years. Nandalal said it's a good proposal. I was told it has to come through Dr. P.B. Jayasundara. I then knew he doesn't like me, so I went to my friend at PwC, Mr. Sujiva Mudelige, and we put the PwC logo on it, took my company's logo out of it. PwC added a lot of value into the policy document. We've spoken of the necessity to introduce legislation to create a bad bank so that toxic assets of bank into these, because in my team I had 2 people who were involved in the trouble assets restructuring in New York. So officials both at banks and the central bank need a mindset change. And if we go with a mindset that we'll take years to implement legislation, I'm sorry, we are not going to dig ourselves out of this hole.
Yeah, that's a wrap. Sorry when lunch calls. I've been asked to stop. Thank you, everybody. Thank you to the
Chanaka,
panelists.
Thank you.
in the 2008 crisis, I was walking past the Fed Reserve, and a friend of mine was showing all the lights were on. All the lights were on. Everybody was working. And when you pass our central bank, I wonder whether all the lights are on. I hope everybody's working hard, at least working from home.
My question actually is, leaving, with all respect to all the problems faced and the challenges of passing law reforms and other reforms that we need through Parliament, and even the legal fraternity, as you mentioned. Ideal case, how long would it take to get a 60% working key reforms set up? Like, just to get all the key reforms set up, how long would it take?
Exactly. I think
Well, there are so many drafts that are in the pipeline for years and years. Unfortunately, they have no votes. Right now, everybody is interested in this amendment of the Constitution and things like that. So these other laws, which have no votes, are the least concern. So that is the problem. So new legislature, we expect my good friend to become administrator and reform all this.
the pipeline, they've been sitting there for, there's one particular draft that I personally was involved with, and it is now last 16 years it's in the pipeline. Reciprocal enforcement in judgments, that is still in the pipeline for the last 16 years. It's a political will, and probably if you want something really done fast, if the financial sector could lobby and say, this is the time that we need to press and bring change, anything can happen.
Harsha, I'm going to ask a cheeky question. Did the banks lobby against it?
Yeah, so the problem is how strong your lobby is, you see. So now, even the legislature, you can see if the banks lobby, definitely your other side will lose.
Okay, thanks. Thanks, Silva.
Thank you.